Assalamualaikum and hi to everyone. My name is Nur Fatiha binti Hassan. I'm from Dan 2. Today, I would like to present about 4 topics in business law. The first topic is law of contract. Definition of contract is an agreement between two or more parties that is legally binding between them. There are 3 types of contract. The first is valid, second is void, third is voidable. Definition of valid is a contract will be valid if all the 9 elements of a valid contract is fulfilled. The effect of valid is if a breach of contract happens, the parties affected may end their contract and enforce their case to the court claim remedies. So, what can be affected parties claim? Maksudnya, apa yang parti itu boleh tuntut nilainya. This is terminate contract, effect of refusal of party perform promise fully in section 40. Second is ask for compensation. Party rightfully rescinding contract entitled to compensation in section 76. Effects for breach of a valid contract. Compensation must naturally arise from the breach of contract. Compensation for loss or damage caused by breach of contract. Second is void. Definition of void is when a contract is void, it is not valid. It can never be enforced under state of federal laws. Maksudnya, untuk kontrak yang tidak sah, ia tidak boleh dikuatkuasakan di bawah Undang-Undang Persekutuan. A contract can be void is 2. The first is the elements for a valid contract is not fulfilled. Maksudnya, unsur-unsur untuk kontrak yang sah tidak dipenuhi. Second is if the contract is not enforceable by law. Maksudnya, jika kontrak itu tidak boleh dikuatkuasakan oleh undang-undang. The case of void is David Taylor and Son vs. Barnett Trading.co 1953 years. The third contract is voidable. Maksudnya, kontrak itu sah ataupun tidak sah. Mana-mana dia akan boleh terjadi. The definition of voidable is a contract will be voidable if it made without the free consent of the parties. Next, remedies for breach of contract. Maksudnya apa yang kita boleh claim jika parties itu langgar syarat. There are 5 remedies for breach of contract. First is damage. Damage is granted to a party as financial compensation for the damage, loss, or injury he has suffered through breach of contract. Second is rescission of contract, cancelling the contract. Maksudnya dia cancel contract yang kita dengan dia buat. Maksudnya di sini allows the innocent party to cancel the contract due to meet misrepresentation by the other party. Third is specific for performance. Specific performance is this remedy is given at the discretion of the court. Fourth is injunction. Injunction is it is an equitable remedy. Five is quantum merit. Quantum merit is as much as he has earned. Certainty. Certainty is agreements the meaning of which is not certain or capable of being met, certain are void. In section 30. The case for certainty is Karupan Chetty vs. Swathian 1916 years. Next, acceptance. Acceptance is when the person to whom the proposal is made signifies its essence thereto, the proposal is said to be accepted. Next, then consideration. Consideration is that a promisee must give something in return for the promise. Then, it is what the parties get from the contract. Contoh kes ni ialah Southeast Asia Insurance Berhad vs. Nasir Ibrahim. Intention to create legal relation. The parties must have intended an agreement to have legal consequences. The law will not concern itself with surely domestic or social agreements. Lastly is legality of objects. If the objects of the contract is illegal, the contract will be considered to be void. The next topic is legal aspects of business entities. There are three business entities. First is sole proprietorship. Second is partnership. And last is company. Definition of sole proprietorship is where one person is involved in running a business for himself. Maksudnya, hanya seorang sahaja yang boleh menubuhkan sesuatu perniagaan itu. Formation for sole proprietorship is only one person running business for himself. Maksudnya, ini hanya seorang sahaja yang boleh berniaga, menguruskan syarikat atau perniagaan itu, kecuali dia hanya boleh hiring employees for support their business. Sole proprietorship ini didaftar di bawah Registration of Business Act 1956. Management for sole proprietorship is sole proprietorship owns and manages the firm himself. Sole proprietorship can employ employees to manage the firm for him. Next, liability. Liability for sole proprietorship is may withdraw his capital, and then liability is unlimited, can sue and be sued in his name. Next, partnership. Partnership is the relationships that subsist between two or two or more persons carrying on a business in common with a view of profit. Formation for partnership is 2% until 20% only. For the professional partnership is no maximum limit. Partnership ini didaftar di bawah Registration of Business Act 1956. Management for partnership is partners are agents of the firm for carrying on its business in the ordinary course of business. Liability for partnership is partnership can withdraw capital and the liability is unlimited. Last business entities is company. Company is a voluntary association of persons formed for the purpose of doing business, having a purpose of doing business, having a distinct name and limited liability. Formation for company is private company is 50%. For public company, a so is no maximum. Company berdaftar di bawah Companies Act 2060. Management for company is members of company is neither its managers nor its agents. There are 6 types of company. First is enterprise. Second is limited liability partnership. Third is private limited company, sendirian berhad. Fourth is public limited company, berhad. Fifth is company limited by guarantee. And lastly is foreign company. Incorporation of a company. Incorporation of a company refers to the legal process that is used to form a corporate entity or a company. The case for business entities is Salomon vs. A. Salomon and Company Limited, 1897 years. AC 22. The third topic in business law is law of agency. Definition of agency is relationships which subsist between the principals and the agent who has been authorized to act for him or to represent him in dealing with others. There are 6 types of agency by formation. The first is agency by express appointment. The principal appoints the agent expressly, either orally or in writing. In section 114 is an authority is said to be expressed when it is given by words spoken or written. Second is agency by implied appointment. In section 140, an authority is said to be implied when it is to be inferred from, first, the circumstances of the case, second, things spoken or written, third, the ordinary course of dealing may be accounted circumstances of the case. The third is agency by estoppel, when the principal himself induces the third party to believe that a person, not an agent, has authority to act for him. In section 190 is When an agent has, with the authority, done acts or incur obligation to third persons on behalf of his principal, the principal is bound by those acts of obligation is he has by his words or conduct induced such third persons to believe that those acts and obligations were within the scope of the agent's authority. The fourth is agency by necessity or emergency. A person who has no authority may become an agent due to the necessity or emergency circumstances in order to protect the principal from any loss. The case for agency by necessity is Springer vs. Great Western Railway.com. Fifth, agency by ratification. Certification acceptance. Condition is contract done by exceeding or without authority. Contract must be legal. Agent act expressly in the name of the principal. The types of agency by authority have three. First is universal. Universal is one who has been given full power to act on behalf of a person or business. Third is general, authorized by the principals to perform any and all acts associated with the ongoing operation of the job or business. Last is special, one who has limited authority granted to him or her through a principal. Last topic in business law is sales of goods. Definition for goods is includes every kind of movable property other than actionable claims and money and includes stocks and shares, growing crops, grass. Land is not regarded as goods. The term of the contract of sale is express terms. Express term is a stipulation essential to the main purpose of the contract. And then the terms of the contract is implied terms. Implied terms is terms that are usually left unspoken and understood between the parties. Implied condition in SOGA. SOGA is sale of goods. Implied condition has two titles, section 14A. Title is also known as ownership. If a person sold the property of others without permission, he is considered as not having the title of the property. Implied condition that the goods correspond with description. It is a common practice where you must describe the goods that you want to buy to the sellers. If the seller does not sell you to the goods as you describe, he is in a breach of condition as to description under section 15. Implied condition as 2 times section 11. Whether any other stipulation as 2 times is of the essence of the contract or not depends on the terms of the contract. Last, implied condition as to fitness for particular purpose. The buyer must mention his purpose of buying the goods. If not, he cannot claim breach of implied condition as to fitness against the seller. Rights of the seller and buyer in case of breach of contract. First is rights of seller. failure of buyer to take delivery. Section 44. Any loss is occasioned by his neglect or refusal to take delivery. Second, right of unpaid seller. Unpaid seller defined. The seller of good is deemed to be an unpaid seller when the whole of the price has not been paid or tendered. Second, when a bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it was received has not been fulfilled by reason of the dishonor of the instrument or otherwise. Yes. Rights of buyer. First is damage. Section 57. If seller wrongfully neglects or refuse to deliver the goods to the buyer may sue the sellers for damage for non-delivery. Second is specific performance. Section 58 of Sale of Goods Act 1957. Application by the buyer for the court to order the seller to perform the contract. Specifically, the seller will be ordered by the court to deliver the specific or certain goods. For watching. So, ini adalah semua daripada saya untuk presentation business law. Thank you.